I'm going to actually talk about, it's very always it's interesting. I said, let me talk about myself first, and then bring the whole issue about media and entertainment law into perspective. I was born and brought up in Mumbai. I went to a college in town, and at that point of time, we had fashion shows were the sort of the flavor. Every other day there were, just as you have T20 cricket, you had fashion shows. So I had a very good friend, and he said that, listen, uh, you know, why don't you assist me in playing the music for a particular show? And I said, okay. I said, what does that entail? So he said, you'll have to put in the cassette in those days, and let the sort of the number rotate. At that time, stop, pause, and play it on again. That was actually my little introduction. I had no idea what media and entertainment was. We were, so we said, all right, let's set it up. We set up, so we had this inter-college fashion competition, and I remember the total cost of the entire show for that one particular day was 15,000 rupees. Now, in those days, there was another particular problem, and that was called entertainment tax. So, collector's office would come and say, you're having a fashion show, and that fashion show is a taxable item. Why? Because as one later on came to know, under the Bombay Entertainment Duties Act, and we followed 1923. Okay, we were in what, 1990 at that time, I think 89 and 90, and it said, very interesting. It said the place of entertainment could be anything, including a hospital or a tent. The entry into the place of entertainment could be a dinner plate, and your taxable rate would be, it was at that time 65% plus 10% surcharge. So on every ticket or pass, you paid 75% to the government. The balance was yours. And what were the various areas in which? So they'd included, of course, fashion shows, puppet show, cabaret, and western dance, all in one bracket. So anyway, as college kids, we said, you don't know about all this, but if you insist, so we paid the tax, and the show went on. So this particular show went on for 6 or 7 years, and what also then happened is, I joined a particular law firm, and what happens is, at that particular law firm, one of the supermodels of that time, Meher Jessia, comes and is a client of the partner under whom I'm working. And then, I suddenly learn about Contract Act. I suddenly learn about, what is a suit, what is an injunction. And, this entire issue of media and entertainment law is sort of revealed. Why am I saying this? I'm saying this that because in those days, okay, media and entertainment law, till very recently, was never ever taught as a subject, even in law school. So we had to learn everything on our own. We had to, and there was, internet was not as fast as it is today, but we had this passion. And for example, when Bryan Adams came down, there was a lawsuit. We actually took the time to go find out, check, see, what has been filed, why is Reserve Bank not giving permissions, and curiosity, they say, kill the cat, and that is how we actually learned. And this is I'm saying this not to show off or to boost my own ego, but I'm saying this is the way, and these are the origins of how entertainment law actually came about in our 100-year sort of plus cinema oriented and I would say cinema crazy city. Even today, if we go to see what was it at that time, it was nothing else but a laissez-faire industry. It was amateurish. Everybody was doing their, sort of, they took media and entertainment as an alternate sort of profession. It was a passion. One thing led to the other, and it then started becoming global. Even today, I have to tell you, what is the state of the industry? It is the fastest growing industry. They say, if you see all sorts of reports, whether it's KPMG or ENY, it's growing at the rate of 12 to 14% per annum. At least for the next 5 years, that is the projection. But again, as an industry, if you are part of the industry, is it recognized truly as an industry? Like for example, if you say work in a factory, you would be covered under the provisions of the labor laws, and you would get provident fund, gratuity, etc., depending upon whether you were a worker or you were a white collar employee. Does that actually happen in the entertainment industry? If the employer is good, yes. If he is not, then you are not protected by the law. So this is one major aspect that really, is where we are. Now, the first thing as professionals within the industry that you actually need to know, and somebody comes to you, is remember that there is something called the Indian Contract Act. If somebody comes and says, okay, well, Mr. So-and-so, you're doing this particular ad, here is the contract. They may come in the beginning or they may come later on and give it to you. Now, what is exactly, why is there the need for a contract? The Contract Act actually specifies that it says that two persons or two entities, if they must be capable of contracting with each other. They should also, there should be the terms and conditions under which the contract is entered into should be, very clear. The terms of payment should be very clear. And then you have several other clauses in the contract, which are, which include, in the event of a dispute, what would you actually do? For example, it talks about jurisdiction of courts. It talks of alternate dispute resolution. You'll hear terms like conciliation and mediation and arbitration. So you'll say, what is that? Basically, what we have discovered is that over a period of time, because of various reasons, our courts are quite clogged with litigation. So they found a very important mechanism, which is known as alternate dispute resolution, where you should try and first resolve it by talking to another a senior person within the industry who can actually resolve the dispute. And in the event that it cannot be done, then you have what is known as arbitration, where a sort of a technically competent person, I wouldn't call him a judge, but an arbitrator actually decides the dispute. Now the arbitration process is very, very flexible. You can meet anytime, even at midnight. You can, the rules of evidence that are much more relaxed. And now under the new Arbitration Act, it is said that you have to finish arbitration within a specified period of time. So when, like for example, one, I wouldn't name her, one famous actor, when many years ago, she had sent me a huge contract, huge not for any other reason, but the fax machine and the roll was so thick. And I asked her, I said, just tell me one thing, forget about everything else. Is there an arbitration clause? And there was a long pause, and she said, what is that? Now you all know what at least arbitration is. The other aspect that you will also sort of realize is, and of course my colleagues will talk about it in great detail, is intellectual property, which is also mentioned in the contract. Now, for example, if you are a model or a writer or an actor, what happens is whatever work you do in for the particular assignment, it's not that you are doing it yourself. It is your image that has created additional rights. Okay. Now these rights may be performers' rights. These rights are other statutory rights which you, as the person who's involved in the assignment, actually has created, and this adds value to the project that is being created, whether it's a television serial or whether it's a film, and that value you're not only going to be paid for it. Like for example, outside of India, you get paid royalty for this. In India, that is yet to come in, but at least you must remember one thing: as far as copyright is concerned, you are the original author, and that copyright, that original author, those rights are fundamental, and they cannot be assigned, at least in the new regime that is now in place. These are all very technical, but I'm just, what I'm going to want you to remember is that whenever somebody says that please sign this, say, model release form or actor consent letter, what they're trying to actually do is take that copyright assignment away from you for a consideration, but always remember in case that you are the first author, that means you're the creator of this copyright, it can never be taken over by anybody in perpetuity. That's something to remember. Then, of course, you have, in case there is a dispute and somebody does take you to court, then what happens? You have the typical sort of suits that are filed are usually either on the civil side, criminal side, my friend will talk about, are usually money claims. Okay, whether it's intellectual property or for a breach of contract, etc. Now, there again, there is a process that is followed. You have, if in case you are the one who is complaining, you have the plaintiff. Then you have the defendant will file his response. Then evidence is led. Sometimes you even the court will appoint a commissioner to lead evidence. I mean to gather evidence, and then finally the matter is argued. The other thing that I would like to sort of inform you is, our courts are not very they don't like to award a very high amount of damages, okay, which is in a sense still a good thing, in case, because if you've done something wrong or breached a contract, the amount of damages that are awarded are far, far less. But please remember, we are moving towards a globalized system, and one fine day, if especially in cases of defamation, etc., slowly we find that the costs that are being imposed are very, very, very high. You also have, okay, one other major aspect of, in case you are in the media and entertainment law space, is that there is the whole question of safety. And the problem is that today we all say that we are an international organized, media and entertainment is now globalized, but you can be globalized only if you have basic safety norms in place. I mean, we saw what happened at the Chowpatty beach, a few months ago, where an entire stage in matter of minutes was completely wiped out. Now, any organization, I'm saying this, it doesn't matter whether you're an artist, you're a producer, whatever. The time has come where we have to have basic safety norms in place. It's like when you're sitting in an aircraft, why is it that, even if you're delayed, they spend that much of time explaining the safety norms to you if you are on a aeroplane. The same way for any, whether it's an event or whether you're shooting outside of India, if you do not have a proper safety code in place, if you do not have insurance in place, no project moves. And this is something that we in India, we need, and we've actually filed a public interest litigation on this subject, and the courts are very, very close to actually, passing orders and ensuring that at least the state of Maharashtra has a, safety code very, very soon. One other interesting development, maybe from next year, the Consumer Protection Act for endorsements might actually apply. As of now, if you're endorsing a product or you're doing something, you usually get away by saying, well, I'm merely an actor, or I'm only the production house, and therefore it's really not I have a brief from the client, and therefore I have executed it, and that's it. I'm not responsible for the product. But there may be a change in the consumer protection law which says, no, it's your duty, exactly like they have in the US. And that is something that might actually change, very, very soon. Well, there are the other, of course, interesting aspect that everybody will, wants to know is, about film certification. That's again a matter of great concern, whether it is television or, and of course we had the famous Utte Punjab case a few months ago. Now, I will just summarize it and say that we have changed from a system of censorship, and it's now very rightly, even the Bombay High Court has very rightly said that it is now a board for film certification. Now, what does that mean? It has to certify whether it is available for viewership in, whether it's a UUA, parental, sort of approval, or whether it is strictly for adults. Even that, and if, as a producer, if you are not satisfied, you can go, there is a tribunal which sits in Delhi. You can go and approach them and say that, no, you've wrongly sort of, classified us as in these particular slot. And it's very obvious. I mean, producers like to get a UA certification because, at least, because then you're for financial and other, and for branding purposes, you like, for example, if it's shown on television, usually the adult content is shown after a particular hour at night. Here you have the whole day to, show your movies and even television serials. And of course, if you're still not satisfied, then you can approach the court of law by way of a writ petition. Now, what happens is, which we've also seen, there's been a trend that the minute you announce that you're going to, your print and publicity is out, some gentleman from the general public gets up and says that, no, I don't like this, and it is offending, religious sentiments, etc. And he files a suit or a case in the High Court or in a district court somewhere. The courts have come down very, very strongly on this. They are saying that, no, once so much of money and effort and if you have proper certification, there is no question of you approaching the court so late, and therefore very often we find that the courts are not granting injunctions except in certain very obvious cases. So that is that. Uh, I mean, of course, we have several, examples. Now, the other thing that I also notice is a lot of people don't know the basic difference. Now, people talk about, what are co-productions, what are international co-productions, how are they, even that is very interesting. It's nothing else but an agreement. It's an agreement between two countries to facilitate the making of movies or television serials, or now you have on the digital format, and where the two governments have an official co-production treaty is to ensure that producers or writers, etc., come together and actually make and produce content that is say both in this particular case, both Indian and Canadian, you have shared the intellectual property between the two, and ensure that the services between the two, that is utilization of not only talent but even technical staff is properly done. You have subsidies and duties in tax credits that are available between the two countries. That is an official co-production. And interestingly, it also means that you can show it at a film festival. Say if it's an Indo-Canadian, then it can be shown as an Indian film or as a Canadian film, depending on which market you go to. Most other productions that are happening, again, it's a very commonly and loosely, are what are known as co-ventures. Now that again is when, say, you have a producer here and someone in France, or in, say, multilateral, say France, India, Germany and Malaysia. You can have people coming together and actually going ahead using different locations around the world, but that will not count as an official co-production. So this is also something that you need to know, and we can take. I can give you several examples of matters which have actually gone to court. I think the one very important one was when Gajni came out a while ago, and we had actually challenged, saying that certain sequences were very, very sort of grotesque right at the end, and that needs to be it was because the Board of Film Certification had not taken cognizance of that. And I think very rightly, although we were against it, I was appearing for the petitioner, I think the court very sensibly said that if we remove that last part in the film, okay, it will change the entire meaning of and the whole sort of the idea that was behind it, and it was supposed to be shown in a very grotesque. So I mean, let's be frank about it. The courts do take a very, very sensible view. They do take the into account everyone that is involved in filmmaking, and they've been passing judgments accordingly.